of prosecutors who are here in this room this morning, thank you for your service and for the things that you do, for your tireless efforts to keep this community safe, and for your unwavering support of me and this administration. I want you all to know that I am here to defend your honor today, and thank you. For the media, I'd like to update you on where we are in the case against Keith Moses. It is the intention of my office to file the following charges tomorrow in this case. Second-degree murder with a firearm against the victim, Natasha Augustine. Second-degree murder with a firearm against the victim, Tiana Major. Second-degree murder with a firearm against Dylan Lyons. Now, I know there are going to be questions about, well, why are we filing second-degree murder charges instead of first-degree murder charges, so I want to go ahead and address that. Florida law requires that we file first-degree murder charges or charges at all within 21 days. First-degree murder can only be filed by indictment in the state of Florida. So first-degree murder charges will go before a grand jury at some point, but in order to continue to keep Mr. Moses detained, it is necessary for us to file these charges as holding charges at this time. This isn't unusual. It's something that's actually done quite normally in the case of prosecuting first-degree murder cases, and that's what we're doing in this case for the reason of continuing to detain Mr. Moses. The additional charges that are being filed: attempted first-degree murder against the victim, Brandy Major; attempted first-degree murder against the victim, Jesse Walden; burglary of a dwelling with a battery with a firearm; shooting within a vehicle; shooting within a dwelling; shooting into a vehicle; shooting into a dwelling; possession of a firearm by an adjudicated delinquent; carrying a concealed firearm; 3 counts of resisting an officer without violence; and trespass in a structure. I anticipate that those charges will be filed by end of business tomorrow. It is the intention of this office to vigorously prosecute this case, to hold the offender accountable for the safety and protection of this community. I want to now move to the letter received by my office from the Office of the Governor on February the 28th. In that letter, there were several baseless accusations that were made. In fact, there were many unfounded assertions and conclusions, and I found them to be disappointing and irresponsible. Making these types of claims are misleading and are danger to our community, which is being intentionally misled with political fear-mongering. My office responded to this letter from the governor's office this morning, and I would like to brief you on what some of those responses contained. As I've referenced many times throughout the attack on my administration, the one adult charge by Mr. Moses was this possession of marijuana of 4.6 grams. I do want to highlight, however, that in 2019, Governor DeSantis executed Senate Bill 1020, and that amended the legal definition of cannabis to require a minimum of 0.3% of THC. Now, what this means is that it became difficult, if not impossible, for us to differentiate legal hemp from illegal cannabis. Included in the press packets that you will all receive today are memorandums and news articles from state attorneys all across the state in 2019 setting forth policies that they would decline to prosecute under 20 grams of marijuana or misdemeanor amounts of marijuana because they were not able to have testing that would provide the evidence that was necessary to go forward. Also included in that packet will be a memorandum from the Florida Department of Law Enforcement setting a standard for what amounts of cannabis they would be testing. It's important, this particular point is important because it's important to understand that this wasn't a policy of non-prosecution by my office, as has been claimed or asserted by the governor and the senator. This is a statewide challenge faced by prosecutors everywhere. However, the governor and the senator chose to specifically select my office for criticism regarding an issue that was raised because of legislation that the governor himself signed. I further want to talk about Mr. Moses's prior criminal history. Now, I've stated repeatedly that Florida law prohibits me from talking about the entire extent of his criminal history. But upon my review, it's important to note that although the sheriff went through great lengths to paint a picture that this was a very violent individual with a very violent past, what I can tell you is that there were 4 felonies in Mr. Moses's juvenile history. 4. And I can tell you that among them were 2 vehicle burglaries where he and other individuals broke into a vehicle, not an occupied vehicle, broke into a vehicle that and wherein they stole things out of the vehicle. One of those felonies was a grand theft in the 3rd degree where he was a passenger in a stolen vehicle. There was no evidence or information in the police report that he stole the vehicle, but he was charged with grand theft in the 3rd degree because he was a passenger in a stolen vehicle. That's 3 of the 4 felony offenses in Mr. Moses's juvenile history. Now, there was a robbery with a weapon charge, and that's one of the charges that has been widely reported. Again, in your packets today, you'll receive copies of all of the police reports for the felonies in Mr. Moses's record, because while I can't discuss the dispositions, the police reports are public record and available to the public. What's important to understand about the robbery is that although Mr. Moses participated in this robbery, Mr. Moses was not the individual who held the firearm during the commission of the robbery. He was never alleged to have been the individual holding the firearm during that robbery. It's important because facts matter. I know they don't matter to the governor, and I know they don't matter to the senator, and sometimes they don't matter to the sheriff, but facts do matter. And it's important that when we report on things, that we're reporting the actual facts of what took place. Given those 4 felonies in Mr. Moses's history, again, all of those happened prior to my being elected state attorney. They happened in 2018 and 2019 when Mr. Moses was 14 and 15 years old. I stand behind the decisions that were made in those cases. And while I can't discuss the specific dispositions with you, I can tell you that none of those offenses would have incarcerated Mr. Moses for life. So when I am asked, why was he out on the streets? He was out on the streets because he did not commit an offense that would have required or even justified life imprisonment. And it's important for the community to understand that as prosecutors, we uphold the law. And upholding the law doesn't mean that we just throw things against the wall to see what sticks. It means we prosecute cases that we believe can be proven beyond and to the exclusion of every reasonable doubt as is required of us by law. So I stand behind the juvenile and adult dispositions of Mr. Moses's prior cases. And I'd like to comment on the fact that while I've been blamed for the tragic shooting that took place 2 weeks ago yesterday, the reality is that the only means to reduce the likelihood of mass shootings in our community is to enact responsible gun legislation so that we reduce the likelihood that there will be more guns on our streets. And without doing that, we will continue to see mass shootings, not just here in Central Florida, but across our country. As such, I would urge the governor to reconsider his permitless carry legislation, as that too will likely increase mass shootings in the future. With regard to the governor's very broad requests for information, I am providing all of the information that has been requested in the first 5 bullet points of the governor's request. However, as to the very last one, information on the number of circumstances of individuals who were arrested for committing a felony or had violated the terms of their probation by being arrested for a crime, had a prior criminal history, and were not prosecuted by this office. It is unrealistic for the information requested to be provided within the time frame requested. Specifically, in order for us to do that, we would have to pull every single case. We would then need to determine if the individual had any prior criminal history. That criminal history could range from a lengthy criminal history to one prior arrest. We'd essentially be looking at more than 350,000 cases. And that would be a cost to the taxpayers of approximately $800,000. Now, I am absolutely willing to provide specifics regarding any cases that the governor would like to inquire about. However, it is not feasible for us to do an audit of this entire office in order to satisfy the governor's political endeavors. My office has, within the time frame provided, pulled together a spreadsheet, which I will reference at this time, with percentages of cases dropped over the last 4 administrations. So as you can see, under the administration of Lawson Lamar, during the last 4 years of his administration, there were approximately 36,452 cases dropped. That is by whether they were declined to be prosecuted, they were no billed, or no pros. Those are all technical terms for dropping charges. There were 36,452. During the 4 years of the Ashton administration, there were 33,277 cases dropped. And during Aramis Ayala's administration, which included the COVID era, there were 38,441 cases dropped. During my 2 years as state attorney, there have been 16,507 cases dropped. That is here in Orange County. If you look at Osceola County, again, under Lamar's administration, it's 88,400 cases. Under Ashton, 8,400 cases. Under Ayala, 7,900 cases. And in my 2 years as state attorney, 4,000 cases. Giving us grand totals of Orange and Osceola. Under Lamar, 103,000 cases. Under Ashton, 97,000 cases. Under Ayala, 96,000 cases. And in my 2 years, 46,000 cases. If you look at the percentages, you'll see it's 43% under Lamar, 42% under Ashton, 48% under Ayala, and 43% in the 2 years that I have been state attorney. These are facts, and facts matter. In the 2 years that I have been state attorney, I have been within 1% of a drop rate of cases. But let's talk a little bit about why cases get dropped. Cases get dropped for many reasons. I've talked consistently about the fact that probable cause does not reasonable doubt make. And what I mean by that is the standard for law enforcement to make an arrest is probable cause, meaning that a crime probably occurred and the individual who they've arrested probably committed that crime. By the time that case comes to our office, however, we must prove a case beyond a reasonable doubt. Beyond a reasonable doubt means that we have to prove that the individual who is arrested committed the crime and that, in fact, a crime was committed. Many cases are dropped here. You can see across the administrations, at least 40% of cases are dropped. And many times the reason is because we cannot convert probable cause to beyond a reasonable doubt. So what's the reason? Sometimes the arrests are not valid. But sometimes witnesses who are willing to testify at the time that an arrest is made are no longer willing to testify by the time the case gets to trial. In fact, this happens very often. So there's not some policy or hidden agenda behind dismissing cases. It just means that our standard is different. This is why it is so misleading to keep talking about how many arrests someone has and comparing that to how many convictions they have, beyond the fact that juvenile arrests don't ever result in convictions. It's problematic because arrests and convictions cannot be compared. What about the cases that are prosecuted and they go to trial and then the individuals are found not guilty? Is the prosecutor's office also responsible for that? What about when prosecutors take a case to trial and the individual is found guilty and given a sentence by the court that is different and less than the plea negotiation that was given by the prosecutor? Is the prosecutor also responsible for that? I would submit to you that we are not. I would submit to you that the justice system is made of several components. One of those components is law enforcement. One of those components is the prosecutor. One of those components is the judiciary, and another is the defense. The entire system is flawed. And to try to place the weight of the entire system on the prosecutor is misleading, it's unfounded, and it is based in politics alone. And the men and women in this office didn't sign up for politics. I signed up for politics, but these attacks are not on me alone. It's on them, and it's not right. In the governor's letter, he states that they want to learn valuable lessons from this heartbreaking event to determine if Mr. Moses was enabled by gaps in our sentencing laws that must be corrected, or, quite frankly, he said, your office's failure to properly administer justice. Yes, there are gaps in our sentencing laws that must be corrected. In December, I provided to our legislative delegation a proposal for a reform of our juvenile justice system that could prevent things like this from happening in the future. I am pleased to say that that bill has now, that proposal has now become a proposed bill out of the Florida House. The bill sponsor is Representative Bracy Davis. I am hopeful that the governor will take action. I know that he did not care enough to reach out to the family of the victims in this case, but I am hopeful that he cares enough to implement legislation that will actually help us to prevent this from happening in the future. In that proposed legislation, I said that we need to raise the age of jurisdiction in juvenile court. All too often, we have things that happen when kids are 16 or 17 years old, and with jurisdiction expiring at the age of 19, that doesn't give us the time that is needed to properly address whatever offenses are committed. Also, when we have very serious crimes being committed by younger children, 12, 13 years old, if we could keep them longer, we could turn around whatever that behavior is that caused them to become violent. We have to invest resources into our juvenile justice system because, as I stated, there are very few crimes that a child can commit that are going to put them in prison for life. So it's not a matter of if they will get out, it's a matter of when they will get out. And if incarceration alone was the tool that we could use to stop crime from happening, as the nation that incarcerates more people than anywhere in the world, we shouldn't have a crime problem. But the reality is, incarceration is just one tool that we can use to provide community safety. Resources are another, and we need to begin putting our resources into programs and other things that will help reduce violent crime in our communities. And I am hopeful that the legislature will take this seriously and that the governor will actually enact laws and put resources into the Department of Juvenile Justice that will help us address the violence that is being committed by our children. I also want to point out that the governor stated that there could be a failure, as they suspect, they said, for my office to properly administer justice. If the governor's intentions were truly to inquire about a failure to administer justice in this matter, it begs the question why he selectively solicited information in this matter from my office. Why did he not also solicit information from the sheriff in their self-proclaimed misstep in failing to test the firearm for DNA? Now, the sheriff said, well, I would have liked to see that case prosecuted. Well, if the sheriff would have liked to see that case prosecuted, then his deputy should have conducted the DNA warrants as he said he was going to and had the gun in that incident tested and then presented charges for prosecution to my office. Our job is to prosecute cases, not to investigate them and provide us with our own charges for prosecution. But the governor said that he was interested in seeing if there was a failure to administer justice, but he never solicited information on that failure from the sheriff's office. Sadly, within a week of the mass shooting here in Central Florida or in Orange County, another mass shooting took place right up the road in our neighboring county of Brevard. The facts of that case were uncannily similar to this. Yet there were no solicitations for public information from the state attorney in that county. And let me be very clear, it is not my intention to bring attention to that state attorney because, like me and my office in the case of Keith Moses, there is nothing that he could have done to prevent that incident from happening. However, if the governor's intention is truly to solicit information regarding failures to administer justice, then I'm curious as to why he's been silent regarding the many mass shootings that have taken place in this state since January. The only logical conclusion is that the governor isn't concerned about failures to properly administer justice unless it pertains to an elected Democrat who is not politically aligned with his philosophies. I've referenced the sheriff a few times in my remarks. I want to say that since I took office in January of 2021, there have been many concerted efforts to prove that I don't prosecute cases, that we don't do our job here at the state attorney's office. In fact, the governor said they don't take prosecution seriously. I've recently been asked to explain why we drop so many gun cases. And I want to talk a little bit about that and many of the other accusations about things that we don't prosecute. Last year around this time, the Osceola County Sheriff provided information regarding certain cases where we did not seek minimum mandatory sentences on drug cases. And when you provide a list of 6 cases out of the thousands of cases that this office prosecutes, then certainly it's going to raise questions as to why certain things happened a certain way. It's important, though, to look at cases in their entirety. Look at the work that we do. It's an entirety. And in response to that particular inquiry, I provided 20 cases where we did seek the minimum mandatory sentence. Facts matter. It is our job to review all of the information in a case to determine what is the most appropriate charge that should be filed and whether or not we can meet our constitutional burden of proving cases beyond a reasonable doubt. And if we cannot, then we are obligated by law to not go forward on cases. So with regard to the latest inquiry regarding guns, in 2021, there were 139 cases presented from the Orange County Sheriff's Office of possession of a firearm by a convicted felon. 22 of those cases are open and pending in my office right now. 51 of those cases were resolved by plea. 54 of those cases were not filed by my office, and 12 of those cases were dismissed. Of the 12 cases dismissed, 11 of them were dismissed for what's called legal insufficiency. Because again, in line with law and order, we have to follow the law. So when you have a possession of a firearm case and you have joint occupancy or constructive possession, as was in the Keith Moses case, there were several occupants in the vehicle, and it was difficult to determine who was actually in possession of the firearm. In those cases where we do not receive evidence that is conclusive about who was in actual possession of the firearm, we are unable to meet our burden to prove that case beyond a reasonable doubt. 2 of those cases, we were not able to prove the element of knowledge, because in proving a case beyond a reasonable doubt, there are certain elements that we must prove beyond a reasonable doubt, and one of those elements in a possession of a firearm by a convicted felon is knowledge. 6 of those were dismissed because there were motions to suppress evidence due to an illegal search or seizure. And after our review of those motions, we found that there was a legal basis to dismiss those cases because of the motions to suppress. There were 2 that were filed motions to dismiss, and after our review of the information, we assessed that the motion to dismiss was valid. In one of those cases, there were witness issues. Of the 41 cases that were legally insufficient, again, 27 of those were joint occupancy and constructive possession. 6 of those cases we were unable to prove knowledge. 4 of those cases were illegal search and seizure. And 1 we were not able to prove the identity of the defendant. 3, we weren't able to prove that the defendant had a prior conviction to make him in possession of a firearm by a convicted felon. In 1 of those cases, the defendant was deceased. In 7 of those cases, there were witness issues. 1 of those cases resulted in a federal indictment, so it would be dismissed by our office. 2 of those cases, the defendant wasn't a convicted felon, and 2 of them were for miscellaneous reasons. I have similar numbers from 2022. I'm not going to take the time to go through them now. The point that I'm making is that it's easy to stand on the outside and say, she's not prosecuting cases. We present so many cases and those cases are dropped. The reality, though, is that there are reasons why. And the main reason being that we have to follow the law. And when we find that the law has not been followed, we have to dismiss those cases. Now, it's interesting because earlier this year, Chief Smith reached out to me from the Orlando Police Department, and he expressed some concerns regarding these cases. And we sat down and we met, and I pulled numbers like the ones that I just read to you, and I went over them with him. And I explained, let's work together to build better cases. There are so many cases that are dismissed due to legal sufficiency. So let's work together so that we can fix that, so that we can build better cases. And we agreed that our office would engage in training with OPD so that we could build better cases. That is a partnership. Not going to the media and saying they're not prosecuting any cases, but coming to me and saying, how can we fix this? What is the solution? Here is the problem. What is the solution? And working collaboratively to come up with a solution on how we can work better together for the safety of this community, which we all care about. I'll end by saying this. I am incredibly proud of the work being done by the prosecutors and support staff in this office. They work day and night to do everything in their power to keep our community safe. Our sympathies remain with the families who have been impacted by this terrible tragedy, and we will continue to do everything within our power to bring them justice. And we will continue to work for the people of this community in Orange and Osceola counties to serve them well, to keep them safe, to connect people to resources so that we can reduce recidivism through programming and other opportunities that are available. We will continue to fight for justice, and we hope to work collaboratively with the agencies and with the governor in doing so. At this time, Keisha will help field questions.
If you can state your name and your station, and then we'll call on you from there, just so that everyone is not speaking at the same time, and we'll start with you.
Bob Hazen from West 2. Any decision about death penalty for Keith Moses?
So when I took office, I enacted a policy regarding death penalty. And what we do is that when the individual prosecutor who's been assigned to the case, which in this case is one of our most experienced prosecutors, Will J., they present a memo, and there is a panel that reviews that memo. The attorney then has an opportunity to basically argue their case for death, and then the panel votes, and then the result of that vote is presented to me, and then I make a determination as to whether or not we should seek the death penalty. So I say all that to say we're just not there yet.
You don't know if you are in favor of that, Frank?
We're just not there yet.
Catherine Silver with News 6. You've talked a lot about Keith Moses' arrest in 2021 and why the gun that was found in that case was never DNA tested. Has your office now followed up with OCSO to ask why they did not test it?
We didn't, but you all did. And I found that last week it was finally sent for testing.
Awesome. Melissa Thomas with Florida National News. Obviously, good news in terms of the bill for that Representative Bracy Davis is going to sponsor. Is there going to be a point where you yourself go back to Tallahassee to actually kind of address that directly with the governor? You know,
thank you for asking that question. I will do whatever I need to do to advocate for that legislation to be passed. And what I'm hoping is that because this has become a widely publicized political back and forth, that doesn't impact the validity of the fact that we need this legislation. So I will continue to push, but I'm also willing to get out of the way if my involvement makes it less likely that the bill will pass.
Are there any more questions?
Right here.
Yes.
Marley Martinez with Channel 2 also. Something that we're looking at is how Orange County's task force is spending money to try to prevent this from ever getting to your office. They've allotted $2 million. How would you like to see that money spent to ensure that this doesn't even reach you?
I would like to see programming for people who have aged out of the juvenile justice system. In Miami, they have a great boot camp program. And what they do is they send what would be youthful offenders to this boot camp. And I would like to see some programming go to that so that when people have rightly aged out of juvenile justice, we can have a boot camp system that will address some of the same things that we're talking about in an effort to turn them around, right? Like I said, the problems that we face are not a matter of if people will get out of prison, it's a matter of when. And we saw that in the case of the robbery of the Amazon driver. One of the individuals there was direct filed to adult court and served 6 years in prison. And within 2 months of coming out, committed another offense. So we need to get to the root cause of why is this happening and what can we do to make it different. And that case is an example of how prison didn't correct those actions. So we need to start working collectively as a community to discover what can we do then to correct those actions. And I know that the boot camp in Miami has proven to be wildly successful, and I'd like to see that come here.
Thank you, Marley. Jetu?
Shannon's the FBO with WFTV in Orlando. In reference to the victim's family and the Keith Moses case and your contact with them, did any of them express to you how they felt about the governor's letter, and also did they express to you about how they felt about their position on the death penalty in this case?
So we have not had an opportunity to have them come into the office yet to discuss the resolution of the case. So my answer on that is not at this time. And their feelings about the governor's letter, I think, were expressed by their attorney in the press conference. I don't really want to get into the personal nature of the discussions that I had with each of them because I just don't think it's right to do that.
Did you have a follow-up? Okay. Any other questions? Yes, ma'am.
Sandra with Trago from Univision. You talk a little bit about Keith Moses cases when he was a minor, and in the past, another minors with the same charge are being convicted as an adult. Why didn't happen in this case?
They didn't think that it rose to the level of a case that needed to go to adult court. But as I mentioned, as with the Amazon case, that individual was sent to adult court, and that didn't fix the problem either. So I want us to get away from pendulum swings that we do one thing and then as soon as something happens we react to it and we swing the pendulum all the way to the other side. Justice is balanced, and we have to be balanced in our execution of justice. So we need to look at if what we're doing isn't working, what can we do differently? And I submit that my juvenile justice proposal will go a long way towards doing things differently.
Did you have a follow-up?
Bob, here's a question to you.
1 second, Bob. She had her hand up.
Hi, Catherine Silver with News 6. There's been several hearings for Keith Moses' current case, and he's not shown up in person to face a judge. Why is that, and where is he being held right now?
I don't have that information.
Bob.
The talk about juvenile cases brings to mind the case from about a year ago. We had this little 10-year-old girl who was accused of shooting a woman during a fight with her mother. Can you talk about where that case stands? Did that ever go to adult court? Was it handled in the juvenile system?
So that's one of those things that I can't talk about. The law prohibits me from discussing. I can't give you any information about that case at this time.
If it had gone to adult court, you could have said that, though, right?
Yes, if it goes to adult court, we are free to discuss it. So I can tell you it has not gone to adult court. Yes, and I would tell you that the thought of sending a 10-year-old child to adult court should be concerning to everyone.
Are there any more questions? Yes.
Melissa Thomas with Florida National News again. In light of the conversation you had with, or the research you did with the case that happened in Brevard County, do state attorneys throughout the state, do you guys have a way of, just for our audience knowledge, do you guys normally meet up and discuss issues like this and ways to resolve it so that you guys can maybe apply pressure at the state level so you have a little more leeway to do a little bit more work, legally speaking?
So yes is the answer to your question. The Florida Prosecuting Attorneys Association is a time for prosecutors to get together and meet up to discuss several issues, and violence among juveniles has been one of them. In fact, prior to presenting my legislation, we reached out to all the other state attorneys, and many of them had already been working on their own proposals on what we can do differently in our juvenile justice system, because they shared my concerns about the increased level of violence among children.
Any other questions? Yes, sir.
David Police, Fox 35. You talked about your bill that is now being proposed. We talked about what are some of the things that could close those loopholes in the legislation, in the gap in the law to help make more prosecutions.
So the main one is giving the court more jurisdiction over the child. What happens now is that when a child goes through the juvenile justice process, the jurisdiction for that child is relinquished to the Department of Juvenile Justice, in that the judge nor the state attorney has a say-so in how long a child remains in a program. And I want to be clear, the length of time is not magical with regards to rehabilitating the child. But the reason the length of time is important is because it removes the child from the community that encouraged them to become involved in violent behavior to begin with. So, for instance, when you have a child who is involved in some sort of gun activity or gang activity, because we are seeing increasing gang activity here in Central Florida, removing them for a few months isn't really long enough to break those connections. However, if we can retain jurisdiction over them for, I don't know, if they're 15, for 10 years, then we can remove them longer and we have more time to kind of deprogram them from that involvement, to get them away from the influences that have led them astray. So that's the major thing. Another thing is tolling juvenile probation. One of the things that happens is when a juvenile violates their probation, the time doesn't toll. And what I mean by toll is the time that they're on probation just keeps going. And if we don't catch up to them until they're about to age out of probation, then when they come back, they age out of probation, and it's as if we never put them on probation. So one of the proposals is also to toll probation, meaning that it will stop until they return. And by increasing the age limit, that will mean that we'll have a lot more time to deal with whatever the consequences of their actions would be.
Any more questions? Yes, Shannon.
When I talked to Chief Smith, he was very clear about you guys working together on those gun cases, that there were a lot, right? So it takes some time to get through it, and there hasn't been enough time. He told us what their issues were on their end, but he didn't tell us what the issues were on your end. Did you find with some of these cases that maybe those cases could have been done better?
So I definitely don't want to get into finger pointing and blame throwing. What I found was that if we worked with law enforcement to train them on what makes a better case, that in the future we can have better cases that can be prosecuted. What I found in my review of those cases was similar to what I read off that I found in the Orange County Sheriff's Office cases. A lot of those cases were constructive possession. So if you have a group of people in a car and there's a gun, then we don't know who had the gun. And sometimes we would just charge the person in the car who, might be the convicted felon. Well, that's not enough for us to prove that case beyond a reasonable doubt. So we've got to have more. A lot of times if we put DNA warrants through, we might be able to get DNA off the gun. Another thing is when you have someone who's driving someone else's car, then depending on what time or when they took that car, we may not be able to prove that they had knowledge that the gun was in that car. And in some instances, we've had the owner of the car come forward and say, that was my firearm, and the individual who was driving the car didn't know. So it's not a matter of who's doing something wrong, and I guess that's the most important thing that I can say today. It's not a matter of who's doing something wrong. It's a matter of how can we work together to build better cases. How can I help law enforcement to understand that they need to look beyond probable cause into how we can make our case beyond a reasonable doubt. And that's what we're going to be working with OPD to do.
But do you agree that these cases, that there should be convictions in these cases? When we looked at a lot of the records, a lot of these folks went on to commit other crimes with guns. They really want these people to be behind bars. There is that mandatory minimum of 3 years if you can prove the case. Do you stand with them on that?
I stand with them that we do need to get dangerous individuals off the street. I don't stand with them that the means justifies the end. So we have to do it legally. And I don't agree that if there's someone in a car who is dangerous and should be taken off the street, that we obtain that conviction by putting a possession of a firearm charge on them that we can't prove that they actually had. That's not what the law says, and I stand with the law. So I do want to work with them so that we can build better cases with all of the agencies. But I'm not going to take shortcuts. I'm not going to say, okay, this is a bad guy. You brought this case. I'm going to see what I can do to make it stick. That's not what the law says, and we're going to follow the law.
What about the mandatory minimums? Do you agree?
We absolutely impose mandatory minimums. You know that. I've sent you cases where I was accused of not following mandatory minimums, and I showed you that we do. The mandatory minimum isn't justified in every single case, but we impose them more than we don't. In fact, there's a policy in my office that anytime a mandatory minimum is going to be waived, a supervisor must approve that waiver. And that goes to another point in this, is that a lot of our prosecutors are very young, and they don't know all of the components of what it takes to approve a min-man waiver. We've talked a lot extensively about the fact that we're experiencing a very high turnover. Right now I have 38 vacancies in my office, and this isn't just here, it's across the entire state of Florida. So I want to be clear, it's not isolated to this office. But with that, when I started as a public defender 20-something years ago, you had people who had been in those positions for 10, 15, 20 years. We just don't have many of those individuals anymore. So I require supervisor approval so that I can get another set of eyes on it to make sure that this is something that should be waived. So I'll give you an example of when we've waived it in the past, and the law allows us to do this. If a gun was found and the individual wasn't using the gun in some commission of a crime, the law says that we can waive a min-man in that case, and we know that happened in a case about a year or so ago where someone went on to potentially commit a homicide. He wasn't convicted of doing that, but potentially that was the word at that time. The individual, the prosecutor who was assigned to that case, reviewed the case, reviewed the circumstances of the possession in that case, and made a determination that that was the right call. And I stand behind that call because while we want to attribute the knowledge of future dangerousness to prosecutors, the reality is we don't know who's going to commit a dangerous crime. And it does happen, but we can't prevent it from happening. We can only use the guidelines that we are given within the law to take cases brought to us by law enforcement and prosecute the cases that we can. Now, I'll tell you that we look at factors like, well, do they have a history of violence? Does that history include gun violence? And those are factors that we use to determine, one, what the sentence will be, two, the fact that the minimum mandatory sentence should be imposed. We do that. But, one of the cases that I received from the sheriff's office included a case where an individual was detained without a warrant. The deputies went in the individual's pocket, took out the key fob, and began chirping through the parking lot to find the vehicle. It's like, God, is that you? Should I not be talking about this? They went to find the vehicle. They then found the vehicle. There was a gun in the vehicle, and the individual was charged with possession of a firearm by a convicted felon. We couldn't prosecute that case because that was a search and seizure violation. You have to have a reason to detain someone, either by a warrant or by reasonable suspicion or probable cause, and it didn't exist in that case. So I know that they were disappointed and they were angry that we couldn't prosecute that case, but ultimately I have to follow the law. So I want to work with our law enforcement partners so that those sort of things don't happen, so that they won't be frustrated and we won't be frustrated, and we can work together, because ultimately the safety of this community depends on our collaboration. And I want to continue extending myself as a partner in that regard.
Thank you, Shannon. Any other questions?
Yes. I want to know your position about this new legislation about guns, to reduce the age to buy guns and to carry guns without permission.
It's catastrophic. It's catastrophic. There's so many guns, and many of the guns that we see that are being used in the commission of crimes are stolen guns. And because there is just continuing increase in the guns that are being allowed to flood our streets, we're going to continue to see guns being used in crimes. So we've got to do something to reduce the number of guns, because what's happening is the more guns that we allow, the more people who are feeling in fear, so they have to go get a gun. And now this guy has to get a gun, and his wife has to get a gun, and his kids, as soon as they get old enough, they have to get a gun, and everyone has guns. And what we're seeing is a lot of gun crimes that happen as a result of road rage, right? You cut me off, I don't like it, I'm going to shoot you. Where we didn't see things like that as prevalent before, because everyone didn't have a gun. We see a lot of vigilante justice, where people put themselves in a position of law enforcement and they start trying to enforce laws on people using their guns. It's absolutely dangerous. And if we do not get responsible gun legislation, we're going to continue to see gun violence in our communities. And unfortunately, that is not something that I can stop.
Any more questions? Yes.
Adolfo Peralta, Telemundo 31. So do you think about your job is a risk because of the influence that Ron DeSantis has?
Yes. Yes. So it became very apparent to me when my colleague Andrew Warren was suspended that my job was at risk. Not because I had done anything wrong, not because I wasn't following the law, not because we weren't prosecuting cases as the governor said, but because I am elected Democrat who is not in alignment with the governor's politics. And that risk is ever present. This has been an attempt to build a basis for a suspension. The last bulleted item in his inquiry was to get an opportunity to go through every single file in my office so that he could find a basis. I have been made aware that the governor's office has been interviewing local law enforcement, that the two sheriffs who serve this county have been working with the governor to try to build a case for suspension against me, that they are interviewing people who leave my office to find out if there are policies that I have of non-prosecution. I will say for the record, I do not have any policies of non-prosecution. However, I will point out that in your press packet today, you will receive other offices who do have policies of non-prosecution, of which the governor has not pursued. So this isn't about whether or not I follow the law. This isn't about whether or not my policies are a danger to public safety. This is about the governor wanting to control the politics across this state. And quite frankly, it's dangerous because this is a democracy, not a dictatorship.
Are there any more questions? Thank you. I'll be on the side with press packets.